Going on YouTube? RDAP Dan here, Federal Prison Time Consulting. Hope you guys are all having a great day. It's been a little while since I've seen you guys, but here we are. And today we're going to be talking about federal attorneys, appointed versus private. Which should you be considering? Which is going to be a better fit? And doesn't really matter. So that's going to be what today's topic is all about. So we'll give everybody a few minutes to join. It's been a little while since we've been live. So if you're joining with us right now, go ahead and drop a comment either in the live section or post a comment on the video and let others know what you think. My daughter was here for a few days, which was really great. She came for the weekend. She just left yesterday, drove her back down to Fort Lauderdale Airport. So it's always sad to see her leave, but she'll be back maybe around Christmas time. So I'm looking forward to that. Hope everybody else has been having a great year so far. It's been crazy with all the pandemic and COVID and everything else. So doing what we can do one day at a time, people helping people, communities method. If you haven't done so, make sure you also subscribe to the channel. If you're interested in booking yourself a consultation, they're completely free. There's a link in the description of the video. So go ahead and check on the link of the description. There's also a link in the live chat right now where you can click on that and you can book yourself a consultation to find out if there's anything that we might be able to potentially do for you. Some of the areas of service that we really focus on are preparing for your pre-sentence report, which right after you accept a plea deal and you go in front of the judge and plead guilty, shortly after that, whether sometimes same day, could be a couple weeks later, depending on your situation, you're going to be meeting with U.S. probation. And at that meeting with U.S. probation, they're going to go through tons of information about your background, your family history, mental health, substance abuse. This is where, if you're interested in qualifying for RDAP, the Residential Drug Abuse Program, you really want to make sure that you have a strong pre-sentence report that has been articulated properly. You need to understand the dynamics of that. For some reason, many attorneys do not go through the process of really properly preparing their defendants for that. Sometimes you might just find out a couple of days before your pre-sentence report, and maybe many of you didn't even know you're going to have a pre-sentence report. Also, one of our strong areas, personal narrative character reference letters. These are going to be the letters that you're preparing for sentencing. That's going to be going to your sentencing judge. We have a whole format for this. We have a platform for this. Scope of services, we'd really like to kind of go through it with you. And this can all take place during the free consultation to see if something that might fit for you. Not everybody's going to be a cookie cutter fit. Depends where you are in your situation. If you're maybe just under federal investigation, if you've just been indicted, some of you may have already been sentenced. You might want to find out what you can do about additional halfway house time, home confinement, First Step Act. Some of you are interested through CARES Act, which is still sending some people home on home confinement. There is also the possibility of you qualifying for compassionate release, which is separate than CARES Act. That's where the court would send you home, which kind of takes it out of the Bureau's jurisdiction. So these are all things that we can discuss during a consultation. So make sure you click on that link, which is in the description of the video. So today we're going to be talking about your criminal defense attorney, whether it's going to be a private attorney or an appointed attorney, and is there a difference? What should you be looking for? In my opinion, there's many misconceptions when it comes to looking to hire a criminal defense attorney or whether you're going to be appointed an attorney. Also, there seems to be some confusion on what it means to be, if you're indigent or if you're just financially struggling or if you're not. There's going to be a financial affidavit that you're going to fill out if you are indeed trying to qualify for a criminal defense attorney through the Justice Department. And it's not like if you're in the state side where you're dealing with a public defender. It's not the same at all. Many of you think you have an appointed attorney and you think this is creating the reason why maybe you're not getting the right help that you need, or your questions aren't getting answered, or you feel like your attorney is pushing you into a plea deal. You don't feel like he has your back. Many of you have told me you feel like your attorneys are working for the government or they're working for the prosecution. You just don't feel like they have your best interest at heart. I can't speak on behalf of every attorney, but I can tell you that we hear this all the time. And the strange thing is whether it's a private attorney or an appointed attorney, we really hear a lot of the same concerns. One of the things that we do here at Federal Prison Time Consulting is we really put you through an attorney accountability situation where we help you hold your attorney accountable by presenting you with questions you should be asking, being aware of what the next steps might be, just so you don't get blindsided by something that your attorney might already just assume that thinks you know this when you don't. There's nothing more frustrating than going through this federal system for the very first time and feeling like you're not allowed to ask a question. Again, we hear so often that every time I call my attorney, it seems like he or she gets upset with me or they're trying to rush me off the phone. You got to remember, guys, at the end of the day, you are the one that is potentially going to federal prison, not your attorney, not me. It's going to be you that is looking at a federal prison sentence. So you have to be able to voice your opinion. You have to be able to ask your questions. And I understand these attorneys deal with a blanket of questions from some defendants. Some questions might not be very practical questions. They might already be kind of an obvious answer to these questions. But needless to say, if you have a question, you should be able to get an answer. So we're going to talk about that a little bit in today's video, and I can even kind of touch on my own personal situation and on what I did and do's and don'ts of what I would have done different if I could have done this all over again. And many of you may kind of feel the pain on this one. So that's what we're going to talk about. Hey, Sean, how you doing? We got Sean over here from Federal Prison Talk. I was over on Sean interviewed me a couple weeks back. So if you guys want to jump over on Sean's channel, if you want to see an interview with RDAP Dan over on Sean's channel, Sean also did prison time. So welcome, Sean. Thanks for popping in, bud. Appreciate it. As I take a sip over here. Yes, I know it is a mammoth-sized coffee cup. It's because I'm a mammoth-sized man. No. After federal prison, I've not worked out quite as much, so I need to get back into that. So I'm not so mammoth. All right. So when I went through my federal prison situation, I originally was appointed a federal defender. Through the CJA, they hired the attorney, they paid for the attorney. Dennis O'Brien was my attorney's name out of Savannah, Georgia. And going through the process, at some point, Dennis was like, "All right, here's the plea deal on the table. It's going to have a cap of 60 months." And I was not prepared to hear that. So when he said 60 months, and I found out he was not referring to 60 months probation or 60 months home confinement, he was referring to a 60-month potential prison sentence. My immediate reaction to that was, no effing way am I going to go to prison for 60 months, as if I had a choice in the matter. So I was very upset with this. I was telling Dennis, there's something we can do. Can't you go back to the prosecutors? I'm a first time. I've never been in trouble before. I have children at home. I'm maintaining a job. I've been out on pretrial now for almost 2 years. How does it make any sense to send me to prison? I just don't understand. And when he was basically telling me, look, it is what it is. There's nothing we can really do about this. This is the government's offer. You know, if we don't take it, you go to trial, more than likely you'll lose. And the amount of time you're facing then could be substantially more than the potential 60 months that I was looking at if I had gone to taking the plea deal. So I was not prepared to hear this noise. I was in denial. I was victimizing myself. I did not want to hear anything he had to say from that point forward. And I pretty much convinced myself that the whole reason for this was because he was a free appointed attorney from the government. So I'm thinking, all right, this guy works for the government. He doesn't really care. He's some pro bono attorney. Some public defender. And I'm thinking of what it might be like in a state side. So I'm just assuming that this guy just didn't know what he was doing and he was out of his league. So needless to say, I had him withdrawn from my case, and I hired a private attorney. Did what I had to do, came up with some money, borrowed some money, and hired a private attorney who is also seemed to be a pretty decent attorney. The thing is I believe if he would have had my best interest at heart, he probably would have said, let me review your case. Instead of paying me everything, give me, I don't know, $1,000, $2,000, whatever, to review the plea deal you have on the table and see what the government has against you. Because basically what ended up happening was I ended up receiving the same exact plea deal. So I turned down the plea deal originally that Dennis had presented me about a year earlier. I turned down that plea deal and was prepared to go to trial. And in the end, my new attorney basically came to me and said, hey, I think we should take a plea deal. I said, well, what kind of plea deal are we talking about? He's like, well, the government's offering you a cap of 60 months. I'm thinking to myself, well, this is the damn same plea deal that was offered to me well before this. And in the end, I ended up getting the same deal. There was no difference except for more time spent, more heartache, more dragging my family and friends through the mud. and a hefty out-of-pocket expense that was already avoided or could have been avoided if I had just stuck with the federally appointed attorney. Now, I'm not going to say there's not going to be scenarios where you might end up with a better scenario with a private attorney versus an appointed attorney, but I will tell you, from the time that I've been doing this now, since we'll call it 2016, doing the consulting, the clients that I've dealt with, and I've had clients that are wealthy of the wealthy, and I've had clients that are, struggling to make their next phone payment. And from the best of the best private attorneys to just a regular run-of-the-mill federally appointed attorney. And I can tell you that the outcomes are very similar. If you put them on a scale, it's probably, whether they would have had a private attorney or an appointed attorney, it's probably across the board going to be the same outcome almost for all of them. Now, some of them did go to trial against, most of them went to trial against their attorney's, recommendations and against their attorney's advice. And so far, all of them have lost a trial that I've at least had the experience of working with. Some of them I didn't work with. If, sometimes we have a client that wants to go to trial and there's really not much for us to do because the mindset of the individual is they just don't want to take any responsibility or accountability. Now, if you're 100% innocent, you really didn't do it, then sure, I'm not going to say take a plea deal, but you also have to weigh your options on, what's the loss of a trial going to cost you versus the acceptance of a plea deal. You got to really balance those pros and cons there and look at the worst case, best case scenarios and look at, chances are the best case scenario going to trial, which is getting found not guilty, is probably not the most common scenario. So you really have to be able to kind of take these factors into consideration. A lot of the effort and time spent on spinning your wheels on trying to get your attorney to find things that can undo the situation you're in. We receive, consultation requests every day. Sometimes we'll deny consultations because we'll look at the context of the consultation, and it's just not something that there's nowhere for us to go with it. Meaning, we'll have individuals that say, "Hey, I was just indicted for this, this, and this federal indictment, and the cops did a illegal search and seizure on my car, and when they got into my car, they found a gun, and I'm a convicted felon. So now I'm a convicted felon in possession of a firearm." I get it. Maybe the cop did do an illegal search on your car. That's going to be something you need to deal with your attorney. That's not something I can give you advice on, but I can tell you that they're probably going to find, they're going to find a way to make it stick. If you broke the law, especially we're talking in the feds, if you did something and they got you, especially something like that, you're driving your car and a cop pulls you over, whether he made it up or not, if there's a weapon in that car, there's really not a whole lot, guys. I mean, you could try to fight that and get it thrown out, but they are going to find a way to make that stick. The defendants and the individuals that we're really mostly interested in helping, not because we want to help somebody more than somebody else, but people that we actually have the ability to create a more positive likelihood of an outcome, are people that are kind of owning the responsibility of the situation they're in, and they're ready to kind of move on to the next phase of what mitigating factors they can start working on now that can present the best possible outcome, which is either going to be, a short sentence or a combination of probation, home confinement, or a shorter sentence with probation, home confinement. There's many different situations that you can put yourself in if you're properly going through this the right way. But if you get stuck on, my attorney's not answering my questions, I think I need a different attorney, you really need to kind of look at what's out there and realize that it's very, very common for somebody to tell me that their attorney's not returning their calls on time, that their attorney's not coming to visit them if they're incarcerated, or if they're like in county lockup waiting for their next court dates, or their attorney is just kind of pushing them into a plea deal. And then we hear crazy things. We have attorneys, I've got a client that called me, what's today? Thursday or Friday of last week, a gentleman that signed up with us. And one of the things that he was really stressing to me, and this was in an email that his attorney sent him, the individual's facing federal time. It's a federal case. There's no state case pending. And the attorney told him that it's 100% day for day if he goes into prison. My client asked him, he goes, "Well, I was told that you serve 85% of your time in the feds, 15% good time." And he said, "No, it's you don't get good time in the feds." This is a private attorney that was hired. And a lot of the times when you guys hire private attorneys, here's one of the other potential downsides. I'm not going to say every time, but one of the potential downsides in hiring a private attorney is you might be hiring a private attorney that mostly specializes in state cases and maybe specializes in, a state that's not even in your state potentially. But he's also taking federal cases. So his expertise might be in state law, and maybe in the state of wherever this individual was, maybe prison time is day for day in the state. And he wasn't thinking, or he got his wires crossed and he's giving the client potentially negative, bad advice or very misleading advice that's having an individual do something that they shouldn't be doing. Also gave him when he asked him if there's any way he could get the government to pay for his fees, he told my client that if you show assets of more than $5,000, that you cannot qualify for an appointed attorney through the federal government, which again, you have to fill out a financial affidavit. And I can assure you, many of my clients, asset-wise, are more than $5,000, and they are qualifying for a criminal defense attorney through the federal defender's office or a private attorney that the government pays for if there's nobody within that jurisdiction that can take this case on. So in either way, you're going to be getting a qualified attorney. However, whether that attorney is well-versed in federal law is what your main concern should be. And most of the time when you're getting an appointed attorney, if it's a criminal justice attorney through the federal government, chances are they are going to be well more versed in the federal criminal law than a private attorney in many situations, unless the private attorney does nothing but federal cases. A federally appointed attorney through the criminal justice department does nothing but federal. They spend their time on getting licensed and updated and qualifications all on the federal system. When it comes to the guideline ranges, when it comes to your custody levels, when it comes to your offense levels, when it comes to what type of prison you're going to go to, most of them will know the difference between a camp, a low, a medium, a penitentiary. They can even sometimes assist you with which ones have RDAP. They're usually going to be a lot more knowledgeable on all of the moving parts that are going to be gathered around this. So don't make the fatal mistake of just thinking because you're paying for an attorney, you're going to get a better service. That comes with that whole white knight thought process where somebody's going to ride in on this giant horse, and the more you pay, the more they're going to do for you. And I don't care how much you're paying, unless you're Jeff Bezos out there hiring a team, you're not going to be able to weaponize yourself against the federal government. They have an endless amount of money. Almost all of their endings end in a plea deal. It's 98% of them end up in a plea. That's why when the feds say they have a 98% or 99% success rate, that's because almost all of them end in a plea deal. If you were to categorize that just in the defendants that go to trial, out of the ones that go to trial, which ones end in a conviction for the government, it's probably still around 70, 80%, still high. There might be a 20, 30% margin there for somebody going to trial, but in the end, no. Don't just assume that you're going to get a much better deal with a private attorney versus an appointed attorney from either side. You need to do your homework. You need to know how to hold your attorney accountable. If you think you're just going to sit there and go through the motions, I've spoken to so many individuals that are months deep into their federal case. I mean, they've been going through the motions for quite a while now. And I'll ask them questions about, they'll ask me if there's any way, and the judge can go below the minimum mandatories. And I'll ask them things like, well, have you spoken to your attorney about, or has your attorney brought up to you a safety valve? And you'll hear questions like, I don't even know what that means, or potential 5K1s, or, they don't know the difference between a minimum mandatory and a recommended guideline range or advisory guideline range. Some of the defendants that have been dealing with their attorney for months and months and months, or even longer in some cases, when they hear advisory guideline range, or they look at their offense level and they see that this offense level can carry from this to this advised, they think that's what they're going to get, and there's nothing they can do to go below that. So the lack of knowledge that the defendants have really does put you at a massive disadvantage for creating the best possible outcome. Your attorney potentially could be doing I'm not going to say they could be doing a better job, but if they're feeding this information to you and they're updating you and letting you know why this is happening, and this is what this is, answering your questions with practical answers and not just playing round robin or shooing you off the phone, you're going to put yourself in a situation to where you're better prepared mentally as well. This isn't just about how much prison time you're going to serve. It's for many of you that are going through this right now, the pretrial phase. You all have heard me say this before. Y'all, I'm back to Florida, clearly. You guys have all heard me say a million times that one of the hardest parts about this entire federal system is what you're going through right now, the pretrial phase of not knowing what's next, how much time you're looking at, not really understanding what prison is to the aspect of compared to what you may have seen on TV or what you might have heard. Many of you, if you've been following my channel or some of the other channels that are out there, hopefully anybody that's out there, especially talking about, federal prison system and qualifying for first-time nonviolent offenders or white-collar individuals, hopefully whoever is posting the content is also explaining that most of you are not going to have any issues in prison other than some minor discomfort from, your food, your regimen, your family. But as far as most of safety factors, most of you are going to be in somewhat of a safe environment. I mean, it's still prison at the end of the day. You don't want to go in there too nonchalantly, but you have to realize it is prison. It's not meant to be comfortable. It's meant to be a punishment, but you're nonviolent. You're not a violent individual. So they're not going to put you in there with, somebody that is, it's got done murdering a family of 5 and, got back and went back to sleep at the end of the night from it. You're going to be dealing with people that are somewhat similar in your situation, whether nonviolent crimes, nonviolent drug offenses, white collar crimes. That's going to be more of the mix of individuals that you're going to be commingling with. So kind of removing the risk factor and the fear factor allows you to focus on what you can be doing right now just to mitigate and minimize how much time you actually serve. And that's what our biggest focus is here at Federal Prison Time, is putting you in that situation to bring you that level of ease and comfort to put the other stuff at bay so we can focus on what really matters. And that's how long are you going to serve in prison? Where are you going to be serving your sentence? What programs can you qualify for that can shorten your sentence? How do you deal with your friends and family right now? What should go into the personal narratives, the character reference letters, and helping you hold your attorney accountable? The whole point of today's video. If you know how to hold your attorney accountable and you're being real with yourself and you're holding yourself accountable and you're dealing with the vulnerable side of this and you're taking full responsibility, you're going to slowly move away from looking for the magic bullet going, well, I only hired this guy because I thought he was going to get me off. Very, very few of you are going to get off scot-free. If you get off with probation or home confinement, that's a victory. That is a win-win for everybody. If you get a sentence that is departed from the guideline range, that is a victory for everybody. If you get a sentence that is at the low end of the guideline range, well, that's what you got. And most of you, Yankton. Hey, we got Juan in the room, guys. Say hi to Juan. Juan L. Juan did some time at Yankton. So if any of you are going to be potentially going to Yankton, here he is right here. Boom. There's Juan. Say hi, Juan. He was a client of ours, guys. He was a long time ago client. He's got some stories to tell. Maybe one day he'll come on the channel and share with us. Anyway, if you've been to Yankton, you got some questions about Yankton, go ahead and ask Juan. Also, spelling error. What's going on? Here's spelling error. Nice to see you. Nice to see you guys. Welcome, welcome. Yeah, I apologize for not being on as much. We've been extremely busy. Home confinement, CARES Act, compassionate release has really kind of just been a recluse of what individuals are going through. So it's really taken up a lot of the time. Or is that just me making excuses? It might be a mix of the two. It gets hard to constantly put out content when you're like, how do I regurgitate the same thing I've said a million times before? But I have to remember there's many of you that are coming to the channel for the first time. So there's nothing wrong with regurgitating it. So there we go with that. I wish I could have had something like this presented to me when I was going through the process. Now, there were some consultants out there, but when I would talk to them, when I would reach out to them, it was almost like, if any of you have been in sales or you don't like to be sold, nobody likes having the fear factor used. Well, if you don't hire me, you're probably just going to be effed and you're going to go to a medium security prison and, you're going to be in a dangerous situation. You're definitely not going to qualify for RDAP. We hear about all of these horror stories of only 10% of everybody qualifies for RDAP. That's why you need to hire us. That's such a misleading statement. And it's like people should feel shame for doing this because they know what they're doing. It's so misleading to the point where what they're telling you is 10% of people qualify for RDAP. Maybe that's true, but it's 10% because the other 90% maybe didn't have substance abuse issues. Maybe there was nothing going on. But if you're honest and open during your pre-sentence interview, the report that's going to be created from U.S. probation that goes to the sentencing court, that follows you into the prison system, if you know what you need to know and you do have some sort of substance abuse issues, it doesn't need to be verifiable in the aspect of you have documented records that you had substance abuse. A verifiable substance abuse order can be your pre-sentence report. So if you're open and honest with the probation officer and you go through your drinking history, or you go through your marijuana use, or you go through your prescription pills, whatever it was, if it was within the time frame of the indictment to where you are now, to getting sentenced or whatever it may be, if you're open and honest and it fits into the criteria, you are technically qualified for RDAP. So you're not in that only 10%. It's probably 90% that you're going to qualify if you give the right information. Our job here at what I do and what our office does is to make sure that to be open and honest and understand the ins and outs and the stipulations of what qualifies, what doesn't qualify for RDAP, so you don't leave something out by mistake. It's not here to coach you how to lie or to manipulate the system. But we've had so many individuals that during their pre-sentence report, because they were not advised by their attorney to be open and honest about their substance abuse, or the attorney didn't really go into detail about how important the substance abuse is, if there was any, that the attorney just let them kind of skate over it, that the client or the defendant may potentially leave that out of fear of guilt, shame, embarrassment, whatever it might be, thinking it's going to get them in more trouble. It might they think they're going to violate their pre-release conditions, or they're going to get a rougher sentence, or it's going to somehow aggravate the judge. I don't know what, irrational thought process is going through the mind of the defendant at the time, but I can tell you that if the attorney told you this information up front and kind of gave you a bird's eye view of what it looks like, they don't even need to know the ins and outs of RDAP itself. They don't need to tell you how much time you're potentially going to get off, but they could just say, hey, there's a program, and if you're going to qualify for it, it's based on substance abuse issues. There's so much information out there that's in writing that they could review, or use a consultant like us to help, put them in a better situation, to put you in a better situation. So the tools are there. Just a lot of people aren't willing to use them. And unfortunately, one of the biggest roadblocks we hit with some of these criminal defense attorneys is they don't like to ask for help. If you ask them a question, they don't like to say they don't know. They'll either give you bad advice or kind of ring around the question and just kind of not really rope-a-dope you. And you get off the phone with more questions than answers. And that can be frustrating. And that leads you to going online and searching because you feel like you're doing your attorney's job, when you should be diving in and looking up these resources and not just trusting your attorney or me or anybody else you're talking to. You need to be putting your best foot forward as well, asking questions, educating yourself, because it's going to alleviate so many issues down the road. And one of the biggest issues is getting stuck and spun on the attorney, thinking that you have the wrong attorney. Most attorneys are not going to be able to go battle for a better plea deal. Now, if there's some discrepancy about money losses and the money loss is incorrect, do your best to get your attorney to get it brought up to the government, to get the government to correct it. But in many cases, the government's findings of what they think it should be is going to be different from what you think it is or what it is. And they may not be willing to budge. This is something that can get argued at sentencing that can bring down potential losses, and which can bring down potential guideline ranges. So just because the plea deal has a money loss of whatever doesn't mean at sentencing that if your attorney makes a great argument for why the money loss is wrong, that this can be brought to the attorney's attention and it can be updated at sentencing. The judge can make a modification to your loss. So it's not set in stone in most plea deals. So you have to kind of know what you can battle, what you can't battle, what's worth battling, pick and choose your battles, simply put. Not getting too stuck on the attorney, thinking the more money you spend, the better your outcome is going to be. Logically thinking, yes, we would think that, because we've all hear you get what you pay for in life. And that's true to a certain extent. But unless you're spending, very, very high six figures for your attorney, you're probably not getting much different than what you would have received as an appointed attorney. Again, I say it again, they are not the same as a public defender on the state side. It's not some guy fresh out of school, fresh out of law school that's sitting in a basement with, 5,000 pieces of paper piled up on his desk. These are actual well-trained assassinating attorneys. If you hold them accountable, they can do very, very big things. However, maybe they get complacent. Maybe they're just kind of pushing you through the motions because they're numb to the whole process and they're not treating you as if they would have when they first got into this to make a difference. So accountability for yourself and what you can be doing, being your best advocate is what is going to create an outcome that is desirable. And that's what we've seen with our clients that receive the best. The clients that call me up that are a pain in the ass, that are going, what about this? What about that? Sure, it might create some uncomfortable moments for me. I'm in the middle of doing something and, I'm taking the fifth call within 10 minutes from the same person, but that person is going to have an outcome that's more desirable for them because they're mentally preparing themselves for whatever's going to happen will happen. So they're prepared. And B, they're not leaving any stones unturned. Maybe there's something that I missed that they read that we can incorporate into the situation or help them navigate. Just because we've been doing this for a while doesn't mean that you're not going to come up with something that we might not have already found out. So I'm not opposed to learning something new. You can teach this old dog a couple new tricks if you want to. Bonnie, let's see what Bonnie's saying. I heard that Yankton was a former college. Does it still have a college feel? And according to Juan, he says, yes, it does. So you want to go to college, go to Yankton, I guess. That's how that works. But guys, do your homework. And remember, if you want to book a consultation, they're free. There's a link in the description of the video. Also at the top of the chat, if you're in the little chat log, there should be a link right there. You can click on it from your phone. If you're on a computer, just click on the description of the video. If you're watching this on the replay, in the description of the video, I think you can also click on the chat log in the replays as well. Free consultation. Book your free consultation. It says 15 minutes, but some of these run 30, 40 minutes. As long as there's nobody booked right after you, I don't mind going into overtime with RDAP Dan. But guys, you got to take this serious. Don't wait till the last minute. Don't wait till things are too late. Don't wait till you messed up your pre-sentence report. Don't wait till you've turned horrible narratives or horrible reference letters. You think, oh, I've got 50 friends. I'm going to get 1 million letters. That's what they want to see. Maybe your attorney's telling you that, but I can tell you guys, most situations, you turn that many letters in and they're never going to get read, in my opinion. I'm sure judges will tell you they read every letter, but if you sit there and tell me that somebody turns in 50 letters and some of these letters are 30 pages long, if you sit there and tell me that judge reads every letter, I will probably point out a judge that has just committed offensive lying. You want to keep this personal. You want to keep it to the point. You want to keep it to the facts. You want to keep it to accountability. You want to keep it to owning the responsibility of what you did, understanding the victims in this, whether it's friends and family or somebody that you actually victimized with the crime. Understanding the dynamics of what goes into these narratives and these reference letters have a huge impact on the potential outcome of a sentence. And if somebody's telling you otherwise, that's because they're taking a lazy path and they don't want to do anything additional. To give proper education and proper information on what goes into these letters, this is why attorneys ask for the letters at the last minute. Most attorneys will tell you, we don't want to submit any letters to the probation officer that's going to conduct your personal narrative because they're not really screening what's going into the letters. So they don't want you to put something in there that can potentially hurt you, obviously. And that's what our job is to make sure that these letters are not going overboard and they're not going off into a rant about something that doesn't matter, or that it's not undoing your accountability or your acceptance of responsibility. Our job is to advance and to complement the whole process to basically present this in front of a judge in a nice bow-tied gift box. We're taking something and making it better. We're polishing it up. We're not having you go in there with rough edges. And if you can understand the value to that, the price of what we charge for our services really shouldn't be an issue. We have payment plans for people. We have sponsors that sometimes donate money to the company that we're able to break out. We're able to use that through our clients that are waiting in the waiting list. So we have ways to put everybody into a situation if they really see the value. So you have to understand that you're willing to put in the work, that you're willing to put in the hustle. You're willing to come up with the financial. There's going to be a financial burden behind this. I didn't commit the crime. I'm not the one that put you in this situation. I also don't have a magic wand or a magic pill that you can take that makes us all go away. So you got to do your homework, guys. It's simple as that. If you're willing to do that, our team over here at Federal Prison Time Consulting can probably do the rest. So we're about 35 minutes right now. I'm probably going to wrap this video up. Does anybody have any questions, comments, concerns? Does anybody have a joke of the day? And I'm going to try to get back to these videos here again. I feel so like rusty. I need some oil, guys. Got Juan saying here, it's up to you. If you're dealing with the feds and you know they have a case, just go with the public defender. Remember, not public defender, federally appointed. So yeah, there you go. Juan said it best. All right, looks like that's all we got. I'm going to wait about another 30 seconds. And if nobody has anything else to say, make sure if you haven't followed us yet that you're subscribed. Also, turn on your notifications on YouTube. This way you get notified when we're live. It's not just on the subscriber list. And we're approaching 10,000 subscribers. It's taken a long time when you compare it to some other YouTube channels that have prison content. But again, our content is not for the everyday viewer. If you're not facing a federal prison case or a potential sentence, my channel's probably not that entertaining to you. But if you are in a situation where you are potentially facing something that's very uncomfortable, such as federal prison, this probably is the best channel for you. I don't think there's a better channel out there for prison content. I know there's some other good ones out there, but I mean, come on, there's only one RDAP Dan. All right, guys, that's all I got for you. Well, I'm RDAP Dan, Federal Prison Time Consulting. People helping people, communities method. Please do not forget to book your free consultation. Until next time, everybody be safe. Love you guys. Have a great week. And let's get through 2021 as fast as possible and put COVID behind us. All right, guys. Peace. Love you all. Be safe. I'm out of here.